First off, there is no rabbinical court established under the bylaws. I refer you to the cemetery case record, pages SA 18 et sec. and A 2207 and page A 2176. Indeed,
So there's no other place than a secular court where this dispute can be resolved?
excuse me, I couldn't hear you.
There's no other place in a secular court where this dispute could be
No,
resolved?
there's no arbitration agreement. When we sought to arbitrate, which was the first proceeding brought, they resisted saying there's no agreement to arbitrate. They said, you have to do it in court, and I've quoted in the brief, they said the court is able to decide this. Secondly,
And there's nothing in the doctrine, Mr. Novak, if there's a dispute among, totally internal dispute among members?
there is no provision in the bylaws for
So
it.
it's okay to bring all of those internal disputes into court?
Your Honor, you're raising a question which I think has been overlooked here. Jones v. Wolf says, we are not going to make decisions based on interpretations of religious doctrine. One side says the doctrine is this, the other side says it's that. Our side says you're free to go to court for this issue, and the Grand Rabbi doesn't have what I will call supremacy in secular affairs.
What issues are you not free to go to court on?
If there were, with respect to this case, there's no issue that I am not free to
But
go.
I asked you a broader question.
All right, excuse
Who's
me.
a member would be...
Right,
and
would that
If
be
there were
one?
an issue of membership, and the issue of membership didn't relate to something that is set out in the bylaws that is secular, then that would be a situation where you could not go to court. However, as I've said at the beginning, the January 18th board meeting, which is the sole issue here, it was not valid because there were only 11 people. That's not a religious question. I can count that. There was no resolution passed. There's not an ounce of evidence. There was no quorum. It's undisputed. There is no religious issue here. And let me just, what the ultimately asking this court to do is to say the religious corporation law, which was designed to protect the members, which has a governance scheme for trustees who cannot be removed, who are entitled, the members are entitled to elect their board of trustees. The not-for-profit law, which we say governs and is not in conflict, provides that trustees serve for certain terms. They can't be removed arbitrarily. All of this mechanism is out the window.
Can the Grand Rebbe, for example, remove someone who does not keep the Sabbath?
Not from the corporation. There's a distinction between the secular affairs of the corporation. There was a case...
Can the Grand Rebbe remove anyone who does things forbidden by the Torah?
Not from the corporation. The Grand Rebbe can say from the religious organization, I want you expelled. But the bylaws provide for expulsion according to an agreed-upon procedure which is set out in the bylaws as required by Section 5 of the Religious Corporation Law. In addition, there's a reference to Section 5's reference to, in accordance with the ecclesiastical doctrines. That was added to deal with the problem the hierarchical churches had. There was an issue whether or not the local trustees could do something different than the hierarchy wanted. It has nothing to do with this congregational situation. Jones v. Wolf, that was a factional dispute, just like this. There were two aspects. First, who has ownership of title? Who gets title? Court rules. There was no implied trust. It belongs to the local church. Then the next question was in the Supreme Court, how do we determine which of the two factions controls the property? Send it back to Georgia's Supreme Court, decided under neutral principles. The concept of neutral principles is there will very well be, in almost all cases, an internal determination by a religious authority, X. A court, if it can apply neutral principles and come to a conclusion, can find not X. That's what happened in Jones v. Wolf. That's what happened in First Presbyterian. In both cases, the religious tribunal or the religious authority said X, the court said not X, based upon a secular principles analysis. If you accept this notion, the Grand Rabbi can take $1 million and go on a vacation. You can't do anything about it. The Grand Rabbi can do anything he wants. And these people, these members, who were supposed to be the beneficiaries of the statutory protection scheme, are helpless. We tried to arbitrate, by the way. The counsel, the respondents were unwilling to go to a neutral tribunal. We were forced to go to court. And they argued, by the way, we're not obligated to arbitrate. So how they can say here now that there's an obligation to arbitrate in a court which doesn't exist, and there's no evidence in there that there is a court, there was no summons. In Jewish tribunals, Beth Din's, you must have a summons, you must have notice of charges, you must have a hearing. Under state law, which also governs any arbitration, you must have all those things.
Thank you, Mr.
Thank you,
Novak.
Your Honor.
And I think you're at bat again, Mr.
Can I have a
Novak.
drink of water before?
You can have a moment if you like.
Thank you. I just want to move my papers.
I think it's a good idea. No. I'm getting a sore throat, but I'll eat it. I want one of those. Mr. Novak?
Madam Mayor, before I get started with
Yes,
questions,
good
may I reserve
idea.
5 minutes?
5 minutes, certainly.
This sounds like I'm a broken record. There are no religious issues in this case either. And if there's ever a real need for clarity, it's with regard to the stability of title. Here's a question as to a transfer of title. The issue is whether or not this court can pass upon that, or it must defer.
Well, apart from the issue of deference, isn't the decision to approve one of these transfers discretionary?
With it would be if there were a discretionary standard applicable here. There is no such standard applicable here. Under Subdivision 8 of Section 12 of the Religious Corporation Law, there's a legal standard that is set out. It's objective in nature. If the transfer would further continue to serve religious purposes generally, then it is deemed to satisfy the requirement of Section 511 of the Not-for-Profit Corporation Law. The decision in the appellate division was in error because they thought it was discretionary. It's an objective standard. They used the wrong standard. That's a question of law for this court, which you can determine.
In 1988, there was prior court approval before that transfer.
Yes, Your Honor.
That procedure wasn't followed here.
No, it wasn't followed, and I believe there may have been a reference in the record by one of the parties that there was a mistaken belief that because it involved a cemetery, there was an exception. In any event, it wasn't done, and we concede that, and we applied retroactively for approval.
Do you have to win the first case to win the second case? And doesn't Mr. Friedman have to be an officer before this transfer could be valid?
I don't believe so. First, the resolution passed on January 14th provided that Beryl Friedman could sign the deed, and he's in his individual capacity, so there's no issue there.
Well, but they say the meeting on January 14th was a nullity.
And I say
You
that...
would have to reject that in order to rule with you in the cemetery case.
I'm saying you can't find it was a nullity because that issue is not before you. It's foreclosed by the failed challenge to our election, which was based on the claim the January 14th meeting didn't satisfy the requirements of the statute, et cetera, et cetera. That, under principles of res judicata, and by the way, that was a separate case.
Okay, but I guess I'm going to sound like a broken record too, but I think this is what I asked before. If I decide today to elect myself as president of your congregation, and no one challenges it for more than the requisite period, I can go sign a deed giving away your cemetery?
No, because first off, the deed was authorized by a meeting of a large majority of the board. There were many, many people there beyond Beryl Friedman who voted for it. It wasn't just him. It wasn't his decision. He happened to be one of the trustees.
But I guess what I'm saying is, they say the January 14 meeting was a nullity, and they had no obligation to challenge it. Regardless of whether you think that's right or wrong in this particular case, couldn't there be such a thing as a meeting that was a nullity and they could just ignore? Like this meeting of me to elect myself?
Well, there are two aspects to the answer. First, when they brought their plenary, they started off with a counterclaim which was converted into a plenary action seeking to invalidate our election, the appellant's election. The allegation was the election was not properly called in the first place because the January 14th meeting of the appellants could not have been called by Beryl Friedman because he was no longer the president because he had been removed. That contention is subsumed in the judgment dismissing their claim. All those claims and any claims that could have been raised with respect to the election or the January 14th meeting are now barred under principles of res judicata. They never chose to appeal that. So this case about the January 14th meeting is not before the court. You're precluded from reviewing it. And that stands res judicata as a given.